Good morning, everybody, and welcome to the D&O Claim Trend webinar for 2019. I'm your host, Sherry Branson, Marketing Manager for Kevin Davis Insurance. I'm now joined by my very special guest, Rachel Plazak. Good morning, Rachel.
Good morning, Sherry. How are you?
Doing well, thank you. Doing well. And Rachel is an Associate Claim Executive with Travelers Insurance. Rachel, this is our fourth year of doing claim webinars. Can you believe it?
I know, time goes fast.
It has gone back. I looked back and I said 4 years. I just can't believe it. It does go by quick. It really does. We're in September, coming into holiday season soon, everybody. And I'd like to welcome everybody and thank you for joining us today. We have some new people from across the country, from the West Coast to the East Coast to the Midwest. And I did want to mention, if anybody has any questions today, we're doing a Q&A at the end. So there's a question box on the screen. You can type your questions into that box, and then we'll answer your questions at the end of the webinar. If we don't have time to get to your question, don't worry. We can answer it after the webinar. So Rachel, I know you've been with Travelers for a little while. Could you explain to everybody what your position is with Travelers and a little bit about yourself?
Certainly. I've been with Travelers since 2002. I started in their New York office handling global marine claims. And then when I moved back to Massachusetts, where I am now, I transferred into the directors and officers liability world, and I've been handling these claims ever since. And with Travelers, we have a dedicated team to this specific kind of insurance. So this is all I handle. And yeah, I live in Massachusetts. I have a daughter who's on travel soccer, so I spend a lot of time traveling and watching soccer and reading and running and hiking. I live near a lot of mountainous areas around here, so it's really,
It's a beautiful area, especially
yeah,
this time of year in the fall.
yes, the foliage
Uh-huh.
is already starting.
Is it really?
Yeah.
Wow. That's fantastic. I love that time of year in New England. I'm from New England originally, but now I'm in Texas where it's about 92. So
Wow, yeah, no.
I'll, I'll take your weather. I'm ready for fall, definitely ready for fall. And I did want to mention that I record all of our webinars and I put the recording on our website, which is kdisonline.com. So you can listen to today's webinar again and all of our past webinars by just visiting our website. So thank you, Rachel. And I wanted to mention our goal today is to review the top D&O liability claims and trends that we've been seeing so far in 2019 for community associations. And I'll start out by just defining what is a claim. A claim is basically a written demand for monetary, non-monetary relief, a civil proceeding commenced by service of a complaint, a criminal proceeding commenced by an indictment, and a formal administrative or regulatory proceeding against an insured for a wrongful act. So that's your basic definition of a claim. And Rachel, being the expert that she is, she's dealing with all different types of claims every day. Can you talk about, some claim trends you might be seeing, Rachel, or what's going on right now in the community association?
Um, Certainly. So we have been seeing non-judicial foreclosure sort of fall out from that kind of action that the boards can take if they want. We see a lot of claims for discrimination when the board denies people their accommodation for a support animal. And then there's also people who will file sort of robo-file claims when there's a public component to a condominium association. Sometimes they have a commercial store on the first floor or something, and it has stairs but no wheelchair access. There are people who will robo-file ADA complaints against those entities, but they will also name the building are insured. So we see a lot of those claims as well. So
Okay,
I would say those are the top three.
okay, great. And now we're going to, can you explain non-judicial foreclosures a little bit, Rachel? Get into that a little.
Certainly. So in certain states, the boards has the right to foreclose upon a unit without going through the court system, but there is a very sort of lengthy procedure of mailings and publishing, if there's going to be an auction. There's a lot of requirements that have to be met in order for the foreclosure to be valid. And if it is not, it can be very, very messy to sort of clean up.
Hmm. So that's something that if an association takes that upon themselves, it can turn into a very expensive claim if
Yes,
there's a mistake, if there's some kind of mistake.
absolutely. Because typically what happens is if a home is foreclosed upon, it is usually then sold at auction or somebody else takes title to it. So once the person files or the original owner who was foreclosed upon, should they file litigation, you have the entity that did the foreclosure allegedly improperly, but then you also have the person who has purchased the property who, typically they want them out because they want their property back. So it becomes very messy.
Hmm. Okay. Okay, great. And the other area that you touched upon, which we have up on the screen right now, is comfort pets, which I know is getting really interesting. I've been seeing so many different stories about it's not always a dog or a cat or a
Nope.
typical pet that people would think of. I saw something on the news the other day where a woman had a pony on a plane. So they're getting bigger. So that's an area that is very sensitive, very sensitive.
Yeah. And, I think boards of directors they have to make some really tough decisions when people make the request. Sometimes there are buildings that are specifically animal free, and somebody with a severe allergy might purchase, a unit in an animal free building. But if somebody with say, severe anxiety, and they get an emotional support animal, if the board were to say, no, you can't have that animal, typically there's going to be a claim for, failure to accommodate a request and discrimination complaint.
Hmm.
So,
Yeah, so that's a very and somebody could buy a unit and not move in with a pet, but get the pet later as well, a year
hmm
later or 2 years later.
absolutely.
And what do you do if it was a petless building and they say they need that animal to for their anxiety? It's a real yeah, that's a very very sensitive area.
Yep.
Absolutely. And I'm sure sometimes you see claim denials, Rachel. Claim denials come up. Can you talk about that a little bit and some of the reasons why a claim might get denied?
Certainly. So the sort of biggest reason would be that we have a specific exclusion. Under our policy, we're the D&O policy, so it's more about decisions that the board makes that we're defending. If it is a claim specifically for property damage or bodily injury, that is sort of more in the wheelhouse of the general liability policy. So our policy has a very broad exclusion for that type of claim. So if it was a claim for, slip and fall or someone's roof collapsed, that would be a pretty standard denial under the D&O policy. We have situations where a board they'll become aware of a claim. They'll get served with litigation. Maybe it's small claims and they think that it's not going to cost very much to take care of. They have a $5,000 retention. They don't want to have to pay that if they can have their attorney handle it. And it balloons and becomes a bigger claim than the small claims
Hmm.
complaint.
It can grow.
Um,
It can grow.
yeah, yeah. So when people hold on to the claim and try to take care of it on their own, and then it balloons, and then they try to give it to us to then jump in and take care of it, that typically will result in a denial. Late notice, sometimes we're prejudiced as well, depending on how it was defended prior to it being submitted for coverage. Um,
So
and let's
basically,
see.
so when in doubt, if a board member or the president of the board or the property manager receives some kind of a complaint or a letter in writing, then it's a good idea to immediately report it to your insurance broker, correct? Like don't sleep.
Absolutely. I would let the agent know.
Hmm.
Um, and I understand people's reluctance to submit what they think is a small claim if they feel like the retention is going to be more, they don't want it on their loss run. But the flip side is you run that risk of having that claim denied. And you're paying a premium for this coverage, and it would be terrible to pay the premium and then not get the coverage because you didn't tender the claim.
Mm-hmm.
That's kind of the
Absolutely.
worst situation.
Right, exactly. So when in doubt, if you get something in writing or you get a complaint, just call your broker and talk to them and show them, what's happening so they're aware of it in the beginning, and then you'd avoid something like that happening.
Hmm.
Mhm.
Absolutely.
Okay, great, great. Wonderful. Okay, now we're going to talk about some of the common claims that we see.
Hmm.
And let's see, we're going to talk about the first one is, Troy's going to move the slide in a second. Here we go. Breach of fiduciary duty. Okay, this is a very common one, right, Rachel? I know I've
Yes.
seen a lot of these coming across. And the example that we have up on the board right now is an association has delinquent owners. They've requested their lawyer to foreclose on the unit for non-payment of assessments. The board president is an investor, and he used his position on the board to find out about the time and the location of the sale, the unit sale, so he can bid on the property. He ended up buying the property, and the unit owner sued the president for breach of fiduciary duty. So could you explain, Rachel, why is this a problem? Why would this turn into a claim that the president is
Um,
deciding to buy a unit?
right. So when a board member volunteers to be on the board of directors, they're basically making a promise that the decisions that they make are going to be in the best interest of the association, not in their own best interest. So the decisions are made coming from that place. And if they don't, then it is considered a breach of their fiduciary duty. In this example, it seems like the board president is taking advantage of information that he has to purchase property kind of, you know,
Mhm.
inexpensively, I guess.
Uh-huh.
Um, so, I mean, that could be problematic. And if it was to go to an auction and be sold, they maybe could have gotten more money for it, or, I mean,
Mhm.
certainly, and that would have benefited the association as
Mhm.
opposed to just benefiting the president. So
Mhm.
that's one
Yeah.
example.
Okay. Yeah. So basically, the board members, as we've talked about in other webinars, they're volunteers, so they may not be aware of the fact that this is a problem. They might think, well, I know about this sale, and I'm an investor, so why would this be a problem? So if
Right.
you're a volunteer, you're not. If there's something that comes up that you're not sure of, it's a good idea to speak to your lawyer, your attorney, and
Absolutely.
get some feedback, as to
Absolutely.
what's a
Yeah.
problem, what's not a problem. Absolutely. So that's breach of fiduciary duty. Oh, and I did also want to mention that I have this PowerPoint that I can hand out to people. So send me an email. I'll mention my email address. It's sbranson@kdins.com, and I can email you the PowerPoint. And as I mentioned earlier, I'll be putting the recording up on our website. Right. So now we're moving on to the next claim. Okay, the violation of CC&Rs. Rachel, this is a very common one. And I know when I moved into my association, I received a big packet of CC&Rs. It's a lot to read, it's a lot to absorb. And I
Hmm.
read it about 8 years ago, so I don't know how much I actually remember. But these are basically the bylaws of every association for people who are joining us today who haven't worked with associations very long. It's basically the bylaws, and the board members have to be aware of what's in the bylaws as well as the owners.
Absolutely. Essentially, what you have is a contract between the association and all the owners, how they are going to all live together. And that's, we call it the governing documents, the CC&Rs and the bylaws, all of it. And it sets forth how the board will run things, how many people will be on the board, how often they'll have board meetings, what type of meeting or what type of changes require a quorum or certain percentage of the owners to be present and vote on things. So anytime that something is done sort of in violation of the CC&Rs, it can result in litigation.
Mm-hmm.
So if they don't have the meetings as often as they is in the CC&Rs, if they don't have enough people on the board, if they don't hold meeting an election to talk about changes that are happening, or a new budget, or they don't get a budget the way that it's set forth in the CC&Rs, all of those decisions can result in a claim.
There's lots of areas that could result in a claim. And we have an example here on the screen. An owner was building a home in a new neighborhood. He sought approval to paint his home pink. It was approved by the association despite the fact that the color was not on the approved color scheme for that neighborhood. Another homeowner decided to file suit against the board, claiming that they violated the CC&Rs, that the board violated the CC&Rs by approving a color that was not on the approved color list. So even things like this, where painting your home a certain color, you know, there's just so many areas where a claim could come in. So it's a really good idea for new board members to familiarize themselves with the CC&Rs. If you live in an association, to kind of keep up to date on what they are.
Absolutely, I agree.
Great. Okay, on to the next one. And breach of contract. Now, in associations, Rachel and I were talking about this yesterday. All the associations are signing, you know, contracts every day with painters. We just talked about painting, landscapers, you know, plumbers, et cetera, et cetera. They're signing contracts all the time, and they don't have a legal background, or maybe some do, but not everybody has a legal background. So you sign that contract. In this situation, there's a landscaping company. They signed a 3-year contract with the company. After 1 year, they decided to fire them because they weren't happy with the landscaping. So the landscaper sued them. So Rachel, I'm sure you've seen a lot of claims like this, right?
Absolutely. I mean, sometimes it's just a matter of the association really doesn't like the work that the contractor is doing, but sometimes it's you get a new board that comes in and they sort of want to pick their own people, and they sort of clean house and they get the landscaper, a different one, a new one. And what's unfortunate about that is sometimes that's done without reviewing the contract with that contractor, because there's going to be they set forth how you can properly terminate a contract. Sometimes it requires written notice, give them opportunity to cure any defect that you feel there is in their work product. And if those things aren't done, then you know they have the right to file suit, and it becomes expensive. And that is under a D&O policy. We provide the defense, but we don't indemnify the damages from that. So that's, you know, can be very expensive, because not only do you now owe the money for the contract that you tried to terminate, but now you have attorney's fees on top of it. So to sort of, you know, put the brakes on and maybe have your general counsel review the contract to confirm that you're terminating it in accordance with the contract, to do it properly, can end up saving a lot of money and headache down the road.
Absolutely. It's a legal contract, so if you're not aware of how to get out of that contract without causing a claim, just call counsel. Call counsel to get advice.
Yes.
Great advice. Great. That's breach of contract. Fantastic. And again, this PowerPoint is available, so just send me an email and I'm happy to send it to you. And now we get into an area, discrimination. And there's all different types of discrimination out there. We were talking about it yesterday, lots and lots of examples of it. This particular one that I'm going to talk about right now involves an emotional support service dog, which we talked about earlier as well. But basically, an association member, a unit owner, filed a suit against their association and the board president regarding the association's refusal to recognize the plaintiff's handicap and allow her the accommodation of her emotional support service dog. The parties attempted to mediate these claims several times. However, they could not come to a settlement, and the matter ended up going to trial. So this could be very expensive, right, Rachel?
Absolutely. And it takes, so usually before trial, with discrimination complaints, oftentimes the complainant will file a charge, like with an administrative agency. If it's something to do with the association, it would be with HUD. And if it was an employment issue, it would be with the EEOC. Both of those avenues provide for a way for people to file a charge, a complaint, without having to have the burden of paying any legal fees. And I think we talked a little bit about this yesterday. What we're seeing a lot of is the administrative agencies take a long time to complete their investigation. So, before it even gets to trial, it's usually there's a good chunk of time that's elapsed. And there is the potential for there to be retaliation once the person files a claim for discrimination. If they perceive that they are being treated differently because they filed the claim for discrimination, they can add a claim for retaliation, and it gets very expensive. I had a claim in Colorado where it was a man who was renting his unit. I think it was Aspen, and he had a woman who wanted to rent the unit, and she had an emotional support animal. It was a animal-free complex. The building didn't allow it. So he wrote to the board and said, hey, I have this situation. And they had no policy for what to do in that case. So they went to their counsel, but it ended up taking a long time.
Mhm.
And the woman ended up moving in with the dog. And the board came up with some rules for her. And it ended up that the man who rented the room or the unit to her, he's the one who actually filed the claim for discrimination.
Really?
Yeah, like on her behalf. And then she filed a separate claim for discrimination and then retaliation.
Oh, wow.
Um, so he had a claim for retaliation because he allowed her to move in, and then the board fined him for allowing her to move in. Yeah, it became very, very messy and very expensive, and it was two separate lawsuits. So,
Wow. I thought you
yeah,
were going to say that the neighbor sued because she brought the dog in and the neighbors
no,
didn't get involved. It was just the owner and the
no,
renter.
yep,
That's wow.
yep.
Yeah.
So,
And you were talking yesterday about, boards suing. We're going to talk about this later, insured versus insured, but boards suing past boards, and then the past board sues the current board. And so there's a
yep,
lot of
it gets
retaliation that goes back
very
and forth.
messy.
And
Yeah.
yeah, it gets bigger and bigger and bigger
Um,
exponentially.
Before I forget, one sort of area of discrimination that when we see it, we know it's not going to go well, is it's sort of like familial. Um, when there specifically like when there's pool issues with children.
Mm-hmm.
Um, and this is a situation where we have boards of directors who are trying to sort of create some rules to protect people. Oftentimes they don't have a lifeguard, and they want to sort of, mitigate any exposure for you know, a loss, a death, or a drowning. So
Mm-hmm.
they try to mitigate or they they try to come up with rules to protect people. Sometimes it's, nobody in a diaper can swim in the pool. Children aren't allowed after 8 p.m. or you need to have a driver's license if you're going to enter the pool area, something like that. Um, Anytime we see claims coming in involving the sort of disparate rules for children versus adults, it never goes well. The
Uh,
findings are always against the association. So that's
uh,
one where I would like sort of heavily caution people to get your general counsel involved to
mm-hmm.
make sure you're sort of going about it in the proper way.
Mm-hmm. To get advice, yeah, because they think that they're, like you said, they're trying to just protect the people in the association and make it safer, et cetera. And they are doing it with good intentions, but
Hmm.
if people feel
Absolutely.
children are being discriminated against, or
Yep.
this group or that group, you know,
Yep.
before you
And
set the
it's,
rules.
I mean, unfortunately, that's a situation where they could get sued for negligence if somebody did drown, if, child or adult, if they didn't have a lock on the pool or, we've
Mm-hmm.
seen claims for that. But so, I mean, that's sort of one of the things that's, I think, hard for people who are on a board is you're faced with making a lot of decisions.
Mm-hmm.
And sometimes it doesn't matter which way you go with that decision. It can result in litigation.
Mm-hmm.
And so you just have to, do what you believe is best for the association.
Mm-hmm.
And in those situations, maybe try to get, again, advice of counsel. I know I sound like a
Mm-hmm.
broken record, but
No, but it
um,
makes sense. It makes sense before you set rules, any kind of rules for the association, get advice.
yep.
Mm-hmm. No, it makes a lot of sense. Great. Thank you. So that was discrimination. And now we're going to talk about employment practices liability. So we saw a situation where an association employed a security guard for the main gate. He'd been employed there for many, many years. He was 72 years old, and the association decided to terminate the employee. They ended up hiring somebody younger. And in response, the older employee ended up suing for age discrimination. And this particular association has had more than 20 employees. It was subject to the Age Discrimination in Employment Act. So this is another whole area where, board members and presidents of boards are not necessarily human resources professionals. They don't have an HR background. So you have employees and you're hiring and firing and you're doing things all the time. So this is a really good area to talk about because this can lead into some very expensive claims.
Absolutely. And what I would say is if a association is going to hire their own security guard, if they're not going to go through a management company, then they really should make sure that they have an employee handbook that is drafted, that sort of sets forth what the expectations are and what the consequences are if those, expectations aren't met. Um, I would also suggest that, if there is an employee who is, constantly running late or constantly calling out and it doesn't seem like a big deal, but, you're going to let it slide this time and you let it slide and you let it slide and then you're done letting it slide. If you don't have the file for that employee papered with all of the numerous times that you let it slide, an investigator is not going to appreciate that you let it slide and then you didn't. They're going to want to see the basis for, I mean, usually it's termination, the basis for that. So I would suggest you always paper the file with what's going on with the employees or
Mhm.
employee. Um, and you're right, people don't have the background, in HR to know what's appropriate, what's not appropriate. And I had a very expensive loss early on in my career. It was two separate buildings, but they shared a property manager. They had two separate policies. And they were looking for a new property manager. And a woman interviewed, and they called to tell her that she got the job. We pick you. And she mentioned, okay, I just want to let you know I just got back from the doctors and I am pregnant. And they said, okay, hang on, let me just check with the board. They called her back and said, the board doesn't want to deal with that. We're going
Oh,
to find someone else.
oh boy.
That's terrible.
Yeah.
That became a very expensive loss because she claimed that as a result of the stress of losing that position, um, that she lost her baby. So
Oh,
that was
wow.
a very tough mediation and very expensive loss. Yes.
Yes.
So
Yes. Yeah. That's why when you're dealing with employees or employee issues, you definitely should speak to your lawyer. Definitely.
advice of counsel. Absolutely.
Mm-hmm. That's a wow.
Yeah.
That's too bad. That's wow. Okay, so that's employment practices liability. And I did want to mention again, if you have any questions about what we're going over, you can see the questions box on the side of the screen. Type your questions into the box, and we're happy to answer your questions at the end. And one more time, I'll mention I'm putting the recording on our website, which is kdisonline.com, so you can listen to this again. And now, Rachel, we're going to talk about something that we haven't talked about in other claims webinars. It's improper towing conversion. And now this situation, you and I discussed it a little bit yesterday, is a student went away to college and they parked their car in the parking lot of their condo association. They left it there for a whole year. And came back and they had found out that the association had called the police to have the car towed. Houston police towed the car, and now the student is suing the association. So I guess they never sent a letter to the student, correct?
Correct.
To let them
So
know, like,
we talked earlier about violation of the CCNRs.
mhm,
Usually it's going to set forth, okay, if you're in violation of the towing policy, we will send you a notice that you're in violation, send a fine, and eventually, if that goes ignored, tell you we're going to tow the car if you don't move it.
mhm.
This student was away, didn't get any notices until she got back and had no car. So now she is suing for the value of the car. So, um, but yeah, that's
Uh,
surprise. Get
yeah,
home.
it's a little surprising that they didn't at least send a letter, saying this car, we know your car is parked here and, what's going on and blah, 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 and all that kind of stuff. So, yeah, they just randomly decided to tow the car, which doesn't make sense. Okay, so that's improper towing and conversion. So that's another area that we haven't talked about before. And now we're going to talk about additional claims that we see. Lots of different categories coming up. We talked a little bit before about the non-judicial foreclosures and the judicial foreclosures. So we've already kind of covered that area. Insured versus insured. Now this we've talked about in other claim webinars. This is an interesting situation where it could be a former board, a current board suing a former board. Can you
Mm-hmm.
talk about, something you've seen happening there where boards have sued each other and what was going on?
Absolutely. So, uh, when you get a new board coming in and they'll check out what the past board did and they'll disagree with, oh, they picked the contractor who didn't have the lowest bid, or they'll find something that they did wrong, and they can bring suit against them, usually breach of fiduciary duty. Um, and what's pretty common is for then the old board to sue the new board. So
Uh, Retaliation.
they retaliate, and oftentimes the way that the claims are presented is they will trigger coverage for both. Um, so it becomes very costly, very expensive when that happens. Um, the example I can think of is I had a claim in Colorado, and it was a man who was on the board. It was the kind of home where people didn't really live there all year round. They sort of flew in for a week here and there, and so there wasn't always a lot of people around. Um, and he built a pizza oven in his unit, and it vented right out onto the ski slope.
Oh,
And the board, when they did finally figure out what was going on, got very upset and sued him. But they sued him and they basically said, you were on the board, you knew this wasn't allowed. Like the way they sued him, it triggered coverage for him. So then he retaliated against them and filed suit against them. And then there was also a property manager who was named, and there was a conflict of interest with her being defended by the same attorney who was representing the board. So we had three lawsuits. Not three lawsuits, excuse me, three law firms defending one lawsuit, and that was my first policy limits claim.
wow.
Actually, I think it was the Book of Business's first policy limits
Oh, it
claim.
was the first one.
Yeah,
Wow. Wow.
lucky me.
You'll never forget that one.
No, I won't. So yeah, we spent $1 million defending
Wow.
um, a pizza oven,
Wow, a
essentially.
pizza oven. Yeah, it started with good, just to make some pizzas,
Mhm.
$1 million. That's incredible.
Yes,
That's,
it really was.
wow. Wow. So that's an example of insured versus insured, everybody. And I have other examples that I can send you as well. So if you'd like other claim examples, let me know. And another category, Rachel, is architectural violations. And this kind of covers really a broad area. And so can you talk about a couple of examples where you've seen this pop up?
Absolutely. We'll have, so usually it's either a unit owner decides to install something, say a lanai, um, and they don't seek approval for it, and the board pursues them and sends the violation and then the fines, and then um, you know, sometimes the association sues them and then they counterclaim back, um, but essentially saying that the board really didn't have the right to tell them that they couldn't build what they wanted on their property, or they'll try to say that the other thing that's pretty typical is they'll say that other people in the neighborhood have built something and that the board hasn't gone after them. So then they're being arbitrary and capricious and pursuing them to, remove what they've built. The other sort of example of this is when somebody does go to the board and says, here's what I want to build. And the board looks at it and says, okay, you can build that. That looks like it's in keeping with the scheme of the neighborhood. And then you have a neighbor who doesn't like the fact that what they've built now completely changes their view, or maybe they allowed them to put in a basketball court and now they hear them playing basketball, or they have the lights on at night, or they're bothered by it in some way. And you'll have a neighbor who says, you allowed this and it's, to my detriment and it's decreasing the value of my property. So, you should never have done this. And they file suit. So, and in some cases, it really, again, the decision that the board makes either way could result in litigation. They could say, yes, you can build this, and then you have the neighbor suing. Or they can say, no, you can't build that. And you have the person who's putting the application in sue them, saying, you denied my application improperly.
So either way, it could turn into a claim.
Either way, yes.
I actually had a neighbor who started to build an addition to his home without getting approval. And then he was telling me halfway through building it, he got a letter from the association saying, stop, you can't do this, you need approval, and da da da. So he was really upset. So I don't know if it ever turned into a claim, but it was potentially a claim.
Yeah, absolutely.
People don't realize they do need to speak to the board and go to the architectural committee, et cetera. And so this is a good thing to fill in, to talk to your board members about, your presidents of the board, et cetera. It's good education for them to tell the unit owners in advance. And now noise complaints, that's another area, Rachel, that's really a broad area. And I was really surprised a few years ago, we started to see claims regarding hardwood floors. I mean, typically when you think of noise complaint, you think of loud music or maybe, kids playing outside or just, that kind of noise. But really, there's such a wide range of noise complaints that are happening. And for a while there, people were putting in beautiful hardwood floors in their condo, and then people below would hear loud walking, and and that became the source of some claims. And that was really surprising to me. So what have you seen in that area?
Well, like you said, the hardwood floors, oftentimes the governing documents will say that there needs to be a certain percentage of the floor covered by a carpet. So, we'll have people saying they don't have it and wanting the association to sort of enforce what is in the CC&Rs. So a lot of times these claims are actually more neighbor versus neighbors who aren't getting along. But well, of course, when I'm going to see it is when the association is brought in. And that can take the form of, like you said, children, playing loudly or loud music. We do get some spiteful neighbors who.
Didn't you tell me about something? I think somebody was playing music and what did they do?
The neighbor downstairs was making noise. The person who lived above them felt that they were doing it intentionally. And so the upstairs neighbor took a huge speaker and faced it down onto the floor and just started blaring music.
Wow.
And the association got brought into that litigation because it says in the CC&Rs that there is, everyone is to live peacefully and, you know, not disturb your neighbors, whatever language they use to say that warranty of habitability. So, you know, people will say you're not doing that because this person is still being really loud all the time. And the board only has so much authority that they can do. The violation letters, the fines, you know, they're not really going to be able to usually go in and like remove the person who's making the noise. Certainly they can, I don't know, suggest they move out, but unfortunately they get brought into it. The other type of noise complaint that I see a lot more so in New York is when they have generators or air systems up on the roof
Mhm.
or elevators in the building. Sometimes we'll get claims that the noise level is exceeding what is allowed or permissible, and then that becomes really like a battle of the experts. We have acoustical testing that is done to make sure it's within range, and if it's not, board needs to make changes to the structural integrity of the elevator or the roof to prevent the noise from carrying. But that becomes, again, it becomes very expensive. It becomes all about the experts.
Absolutely. And it's very technical when you have to bring in acoustic experts and then to fix whatever's wrong. They have to make sure they fix it correctly, and yeah, that can really add up and get very expensive. So we have noise complaints about hardwood floors, about elevators. It could be dogs barking. It could be neighbors with music, loud music and parties, etc. So this is like a very broad area that we're seeing noise complaints in. Great. And now we talked a lot earlier about, you were saying speak to general counsel, you know, that's a great bit of advice. And I did want to mention that if you have a traveler's D&O policy, we have a risk management helpline that people can call. And it's a great tool, it's a great resource. You basically get 1 hour of free risk management advice. And we're going to be putting the phone number up on the screen in a minute. It's run by a law firm, Cole, Scott, and Kissane. And basically, you can talk about your issue. If you have a question, you think something might be a claim, potentially be a claim, or there's something that you're handling that you're not sure. But this is a great resource to take advantage of and to use. And Rachel, this ties right into talking to counsel, you know, and getting
Absolutely.
talking
That's why they
talking to an expert.
Yeah.
Yep.
It's a very nice feature of the policy.
This is the phone number up on the screen, 855-548-8656. It's open Monday through Friday, 8 to 5 Eastern Time. So if you know any of your insurers that need this number or need the help, feel free to share this with them. And again, I can always email you the PowerPoint. So send me an email to sbranson@kdins.com. And now we're going to put up the phone number for the claims hotline, which is on all of the travelers' policies. If you have a traveler's policy, it's an 800 number right there. And that's where people report the claims. So they just call a 1-800 number and they report it. And great. Okay, now let's see if we have I do have a question here. Oh, actually, Rachel and I were emailed a question yesterday, and it's from Ron Sorotsky from Illinois. Thank you, Ron, for sending in your question. Ron and his son are on the webinar today, and Ron wanted to know, had we seen any claims that was it 850,000, Rachel? He was wondering if we'd seen
I
any
think 800,000.
So he wanted to know if we'd seen any claims that had reached that, and can you talk about that a little bit?
Certainly. Absolutely. Typically, those claims, it's going to be the defense costs that we incurred defending the claims. I think let's see, I know I had a claim in New York that was a discrimination complaint that we ended up paying a significant amount of money to resolve it. It wasn't just the defense costs. And the claim in Florida with the property manager, it wasn't $800,000, but it was very expensive. I would say in like the 200,000 to 300,000 range. And then I believe another part of that question was claims where we have paid the policy limits. My experience, those claims, I've had a few of them, unfortunately. the one in Colorado being the first. Typically, that is going to be claims that involve a conflict of interest, which requires us to retain more than one law firm. That seems to be the trend in what erodes the policy. So
Okay.
hopefully that answers your question.
Yes.
If not, let me know. We can take it offline.
Ron, if you need more information about that, feel free to send us an email and we can give you a call. Thank you, Ron. And Rachel, I have another question from Andrew S. Andrew would like to know, can we touch on the importance of having fully completed applications?
Absolutely. So it's problematic when, let's see, the example I can think of is if the insured does have an employee or employees and they don't disclose that, and then there's a claim involving the employees. Unfortunately, that could end up in could result in a denial of the claim because the policy was written and the premium was based on there being no employees. So it was not for, employee liability was not sort of taken into consideration when the policy is written. So yeah, having the application filled out properly and entirely is very important.
Mm-hmm. Absolutely. And with Rachel, it's true that you might start out with the original application having no employees, and then 2 years later, the association might hire a couple of employees. So it's always a good idea to update the application as well and let the broker know that something has changed within your association so you have the proper coverage.
Absolutely.
Great. Fantastic.
Absolutely. I think it would be, yeah.
Great, great. Wonderful. Well, thank you, Rachel. Thank you so much for a great webinar. And thank you, everybody, for joining us. I did want to mention again that I put the recordings up on our website, which is kdisonline.com. And if you think of any other questions you'd like us to answer, please send me an email to sbranson@kdins.com. And thanks, everybody, and have a great afternoon. Take care.
Thanks, Sherry. Bye-bye.
Thank you. Bye-bye.